Okay, so in this video, I'm going to address the 5 most watched estate planning videos of the last decade on my YouTube channel, and I'm going to summarize those videos. Okay, so this video is different than really all of the hundreds of videos that I've done before, where on all of those other videos, I just niched down on a little bitty topic related to estate planning and then kind of dug in and got in the trenches on a particular niche topic. This one's different. And by the way, I'm doing this at the beginning of the year. Happy New Year, Happy New Decade. So I wanted to take this opportunity as we go into a brand new decade and revisit and I've done hundreds of videos, but I want to revisit the 5 most watched videos on this channel and give you a little background and kind of have a little fun with it. So, and as we make our plans forward for 2020 and beyond. So here they go. I'm gonna go in reverse, in reverse order. All of these videos, while my YouTube channel is not a big deal, I know that there are many channels that are getting millions, if not hundreds of millions of views. But all of the 5 videos that I'm gonna go over with you that I made have had, each of them has had at least 10,000 views. So they were watched, quite a bit, much more than some of the other videos, which may have only had, 100 views or so. So I want to go over, why they're popular and maybe some of the background as to why I made that particular video. Okay, so here we go. Number 5. My number 5 video was how to keep your sons-in-law and daughters-in-law out of your estate. So the reason I made that video was because over the years, people would come into my office and they'd say something like, Paul, we really don't dislike our son-in-law, but we just want to make sure that what we have goes to our daughter and that, it doesn't go to him. So that happens a lot. And so really part of estate planning is making sure that your stuff stays in the family, or sometimes people call it in the bloodlines. So I said, well, I got to make a video about it since so many people are asking me about it. So in that video, we talked about how parents can leave, their estate to their children outright. That's kind of the simple and traditional way to do it. And when you leave it to your child outright, it might get, mixed up with other assets that they have with their spouse. And if they get divorced, they might lose some of their inheritance. And so there's a couple of other options. We talked in the video about how you could leave assets to a trust for your child, so that when you pass away, if your child's name is Cindy, you can leave assets to the Cindy Trust, maybe even name Cindy as the trustee, so she still fully controls her trust, but at least it's set up in a way when you die so that it's kept apart from assets that Cindy may have with her husband. So if she gets divorced, Cindy's husband doesn't get anything. And then we talked even further about the next step, which is leaving things to a Cindy trust, but Cindy is not the trustee. Somebody else is the trustee. And what that would do, perhaps, is keep Cindy's husband from having influence over Cindy, where he may influence her to take money out of her trust if she's the trustee. But if she's not the trustee, then Cindy's husband loses that power. So we talked a lot in that video about how to keep your son-in-law, your daughter-in-law, maybe your ex-son-in-law, your ex-daughter-in-law out of your estate. So that was a good one. That one got a lot of views. Moving on to number 4 was and 4 is kind of similar to 3, that starts to touch on the little bit touchy subject of avoiding probate. So number 4 video was the who should and shouldn't take steps to avoid probate. So I started addressing in that video the possibility that, maybe some people should try to avoid probate, and then maybe some people shouldn't, where most of the stuff you see online is all about everybody needs to try to avoid probate. So I took that angle, and we talked in that video about how the people that should avoid probate are those who want their survivors to avoid the probate, not only in their state, but in other states where they perhaps own real estate. And when someone owns real estate in their home state and in another state, there's multiple probates when they die, because the probate in the home state doesn't govern the real estate that's owned in another state. So you got to go hire a different set of lawyers, do another probate. It's a mess. It's difficult. Nobody likes it. So that's one reason why people should avoid probate. Others is this incapacity planning. Sometimes people will call it the living probate. It's this guardianship. And sometimes the power of attorney just doesn't do it. Third parties don't sometimes honor powers of attorney. So if your assets are in a trust, your family can avoid that living probate because you'll have named successor trustees who can step right in your absence or your inability to manage assets for yourself. That's another issue. Who else should avoid probate? Well, those people who want to reduce their estate settlement cost. If your estate has to go through probate, there's going to be lawyer fees, there's going to be court fees. Sometimes those can be reasonable, sometimes they can be what many perceive as unreasonable and really expensive. And if you're a married couple, the family's going to go through it twice. So if you want to reduce or in some cases eliminate estate settlement costs, maybe avoiding probate is something you should make an attempt to do. And then we talked about people who should attempt to avoid probate are those people who just want to plan ahead and make things as easy as they can for their survivors. Those people typically want their survivors to avoid having to go through probate. So those are some of the reasons why people should and why people shouldn't take steps to avoid probate. And this is going to touch on some of the Louisiana specifics. We have something called a small succession affidavit. Kind of tricky to plan for it, and it's all, the stars have to align. But when somebody in Louisiana dies and they have no will, and they have less than $125,000 of assets, then probate is eliminated. Now, the assets, because the person didn't have a will, have to go to the people who stand to inherit them under our intestate law. But if that's okay, maybe it's in your best interest, if you meet all of those qualifications, to not have a will and rely on the small succession affidavit procedure to handle the estate settlement when you die. Or maybe there won't be a probate when you die, so there's no need to try to avoid it. I met with a woman yesterday. She didn't have a whole lot, but her husband died about 6 months ago. I asked her, did you do your husband's probate? She said, we didn't need to. The house was solely in her name. He had an IRA of which she was the beneficiary of, and they had a number of joint bank accounts of which she still had access to, so there just wasn't the need for a probate when he died, so there wasn't a need to attempt to avoid the probate when he died. Touching on a little bit touchy subject, sometimes, especially here in Louisiana, where, in other states, I think, basically 100% of the people say it's a no-brainer. We don't want to avoid probate. All the lawyers say it, all the financial people say it, all the consumers say it. But here in Louisiana, we still get a lot of, I'll call it, this is the touchy area, you might be told by a lawyer who handles probate or a lawyer who handles successions, it's the same thing. They might tell you, probate's not that bad, don't worry about trying to avoid it. And it's usually lawyers who handle those probates and earn a living from handling those probates are the ones who typically advocate, don't try to avoid probate, it's not that bad, is what they're telling you. So we see a lot of that, where some people don't worry about avoiding probate because they've been advised that way. And then some people say, who shouldn't worry about avoiding probate or take steps to probate, is I've had people genuinely from the heart come into the office and say, I don't really want to avoid probate because I really don't care if there's a probate, I'll be dead. So I'm going to leave everything in my name, and I'm going to have a will that says where my stuff goes when I die, and I'm going to name an executor. But if my survivors have to go through, some stuff and some hurdles and some hoops to get what I got, so be it. I won't be around. I want to make things as easy as I can for me. I'm just going to leave everything in my name. So I had a little fun with that video and got a lot of views, got a lot of likes. So that was number 4. Number 3, along the same lines was this, should you have a will or living trust? And I had fun with that video because in the thumbnail image, I think my school, LSU, was going through a recruiting process at that time, recruiting their football players who are now playing for the national championship in just a few days. And so I had fun with that thumbnail. I made 2 hats or images of 2 hats. One said will on it, one said living trust. Kind of a play on the recruiting story where high school seniors will sit at a table with hats of different schools, and then they make their decision known where they're going to college by picking up one of the hats and putting it on. So I had a will hat and I had a living trust hat. So we talked about the basics in that video of people sometimes choosing the will hat, but they do that and they write a will, they leave assets in their name. When they die, assets are frozen. Their survivors will hire lawyers like myself. We guide them through a court process because it's been determined, even if someone has a will, if they have assets in their name when they die, the survivors have to hire lawyers, go through a court process. It was determined many years ago that our court system, our government, will oversee the administration of someone's estate when they die, and they'll oversee the distribution of it to the appropriate heirs. Judges get involved, lawyers get involved. So that's the traditional way to put your legal affairs in order. That's if you go put on the will hat. Or you could put on the living trust hat and create your living trust, which replaces your will because your trust says where things go, but it is important that you transfer those probate assets to your trust, have them titled in the name of your trust when you die, so that nothing's controlled by the trust unless things are titled in the name of the trust. So we talked in that video about how kind of a popular tool to avoid the attorney and court involvement when you pass away is to create your trust, transfer title of assets to your trust. When you die, you will have named a trustee of your trust to handle things, and you will have named beneficiaries of your trust to receive the trust assets, and that trustee, when you die, can disperse assets to your trust beneficiaries without any court or attorney involvement. So we had some fun with the two hats, and you can watch that video if you'd like and pick which hat you want to go on. All right, so number 2, going in reverse order here, was the Medicaid 2018 assets and income limits with analysis. Don't ask me why, but every year I made a video about the 2018 Medicaid rules. I made that at the very beginning of 2018, and I made another similar video in 2019, Medicaid income and asset limits with analysis. Boy, the 2018 video got a whole bunch of views, and the 2019, not so much. So we talked about how much people can have and how much of their income they can keep when they or their spouse go into a nursing home. I'm about to make the 2020 Medicaid. I'll give you the quick highlights there. Fast forward, so you might not get all of this, but if you have a married couple and one spouse goes into the nursing home, one stays at home, that couple can have in 2020 $128,640 of assets. That's called the Community Spouse Resource Allowance. The rationale: the one who stays at home needs something to live off of. It's not the typical $2,000 limit for a single person. I'll talk in the 2020 video about how the spouse's maintenance needs, how much income they can have. So if one spouse is in the nursing home, another spouse is home, that spouse who's at home, called the community spouse, gets to keep all of their income. If their income doesn't meet this $3,216 monthly amount, they get to keep enough of their spouse's income to get them up to the spouse's maintenance needs amount of $3,216. Again, these are Louisiana numbers, but many of the other states use the same numbers because they come from the federal government. And then there's a new number for how much of your home equity is not a countable resource. Most people are fairly familiar with that. If somebody goes into a nursing home, they've got to spend their countable resources, but their home is not a countable resource. It's an exempt asset, but if it's in your name, it's subject to the Medicaid's estate recovery rights when you die. Here in Louisiana, for 2020, the amount of home equity that is exempt is $595,000. So you can't have $1 million home and expect for Medicaid to pay for your nursing home care, the limit $595,000. So had a lot of fun. That's a big part of estate planning these days, is people wanting to plan ahead at least 5 years in advance. Do it while you're healthy to protect what you have from the nursing home. And then my number 1 video of all videos, more than I think 75,000 views at this time, is one that I remember the morning that I made it. And the title of that video is called "If You Have a Revocable Living Trust, Watch This Now." And the background on why I made that, I was mad. I was mad because years earlier, I had helped a family set up their revocable living trust, and I transferred their home and their real estate to their trust. And I gave them all of the instructions and all of the paperwork that they needed to go retitle their investment accounts into the name of their trust. because I couldn't do that for them. I certainly don't have any access or control over their investment accounts, and they didn't do it. And they died, and they still own those investment accounts in their name. So when that happens, we have to use the pour over will to go through the probate and transfer those accounts into their trust. But there were people who didn't like that we had to do that. The financial advisor, the children, they didn't get it. And so they wanted to blame me for having to have a probate to get that account that the parents didn't transfer after being instructed to do so. And after telling me they were going to do it, they didn't do it. And so I was mad. And so like, I'm going to make a video while I'm mad telling people that they need to fund their trust. And so funding a trust is retitling assets that are in your name into your trust so we don't have to go through the probate process when they die. So I don't know if the reason it got so many views was because I was kind of mad and animated, and I don't get mad. So, but I was, you know, I had a little, you know, had some energy going on there. And so that one still today gets a lot of views every day. And it's been my most, you know, popular video of the last decade. And so I do have a couple of honorable mention videos. I went through the top 5, but I got to mention number 7 and 8. They're the same topic. It has to do with my 2018 and my 2019 updates to the estate and gift tax law. So I just did a 3-part series for 2020. You can check that out if you want to, but you know, in every year the estate and gift tax laws change. So for 2020, the estate tax exemption or the exclusion amount is jumping up from $11.4 million to $11.58 million. The how much you can give away to as many people as you want to every year is staying at $15,000 for 2020. It gets adjusted for inflation every year, but it only goes up in $1,000 increments. But in the 3-part 2020, the 3-part series, part 3 was all about how the sunset and potential clawback, where on January 1st of 2026, this $11.58 million exclusion amount, which is going to increase every year as it gets adjusted for inflation, is going to revert back to $5 million adjusted for inflation on January 1st of 2026. So you can check out that 3-part series on my estate and gift tax for 2020 with the analysis to find out what you want to, what the deal is there. But those 2018 and 2019 videos that I made on the estate and gift tax updates were also very, very popular. Okay, so what's my plan for the next decade? It's been a lot of work, but it's been a lot of fun. I will tell you that making these videos has made me a better lawyer, a better advisor, a better consultant, because it forces me to not only collect my thoughts, but research things. I want to make sure I'm accurate on these videos, and it helps give me some practice communicating these issues so that it just makes me better as I talk to people about these issues over the years. So I plan to do more of it. I've seen, you know, some nice growth with my channel. I'll tell you, in 2020, I kind of have earmarked, and these are some things beyond my control, but we'd like to get it up to about 10,000 subscribers, and I'd like to get the total views up to a million views or more. So I'll have to do that. Personally, I'm going to have to publish a lot of videos, and they're going to have to be of high quality. So if they're not high quality, people won't keep watching, they won't share them, they won't subscribe, they won't give them the thumbs up. So what I'd like you to do at this point here is give it a thumbs up, make sure you subscribe, and hit the notification bell so you don't miss anything. And then the other thing that could really help me is there's a share button on your screen, probably some arrow. Go ahead and hit that share button, and then by email, by text, whatever way you can, just share it with others who may have an interest in this topic of preserving what you have and making sure it stays in the family and passes along to survivors in as easy a manner as possible. I look forward to sharing with you a lot more information. Look forward to reading your comments, and turning those comments into new videos. And I hope you have a great new year and a great decade. We'll see you next time.